Hi, this is Cora Stack here, Dr. Stack. I want to explain this point again because it's something that I think it's, as I say, it's something that I've stumbled upon as a result of, I suppose, adversity and challenge in the high courts and trying to understand, as I said recently, how I ended up in a position, in a very difficult position, and trying to understand that point in terms of sequence that I tried to look at in kind of starting from a particular point and how did I, and looking backwards. So I call that, after many months, I call that the constitutional blind spot. And I also looked at the different techniques and doctrines that are used to shut down constitutional cases, and I came across a number of these that are used internationally. But a particular one of great concern to me was called procedural reframing. So also the doctrine of non-justicability and abusive process and personal grievance, and these were all words that were used in my judgment, and I thought, I used balance of convenience a lot in my case, and it didn't seem to emerge in the judgment. So that's actually another doctrine. That's brilliant, that one, the balance of convenience. So how procedure can silence democracy. So my name is Dr. Cora M Stack, as you know. In this video, I want to explain a set of ideas from my recent work on constitutional democracy, the constitutional blind spot, procedural reframing. I mean, this really is shocking to me. Doctrinal layering and the way timing can determine whether constitutional safeguards are real or theoretical. Now, as I understand it, this is new. This is a new insight into constitutional law. So this is for maybe the ordinary man in the street may think this is nothing, but this, in my opinion, is a very deep insight. I'm going to explain this in plain language because these issues are not only for lawyers, academics, judges, and politicians. I assume a lot of my viewers would be legal people, or perhaps related to those kind of people. So, but these affect citizens. They affect democracy. They affect whether constitutional rights and safeguards can actually be used in time, including litigants like myself, challengers. The central question is very simple. What happens when a constitution appears to provide a safeguard, but the legal system cannot review the issue in time to prevent or correct the alleged constitutional defect? This is the problem I describe as the constitutional blind spot. A constitutional blind spot arises where a right, remedy, route, or safeguard exists on paper but cannot be effectively used in practice because of timing, procedure, delay, cost, judicial restraint, institutional caution, or legal doctrine. In simple terms, the safeguard exists, the court exists, the procedure exists, for example, judicial review, but the answer comes too late, or the real constitutional questions never reached at all. Now, this is what I found. I mean, I was awestruck when I found this out, that the real question is never reached at all. Let's see what that is. This matters especially in election-related cases, nomination process, referendums, emergency decisions, or other time-sensitive democratic events. So this really blew me away when I discovered this. These processes move quickly. Nomination windows open and close, as we know. Deadlines pass. Ballot papers are prepared, elections take place, votes are counted, results are declared. But the time the legal system is ready to give a constitutional answer, the political event may already be irreversible. So I was comparing it to the kind of a relativity theory, inverted commas, of constitutional law in my previous video, as I was thinking about it as a mathematician. This is why timing is central. In ordinary life, we know that timing matters. A doctor may know the correct treatment, but if it arrives too late, the patient is not helped. A fire brigade may arrive, but if the building has already burnt down, the response has failed in practice. A court may eventually give a legal answer, but if the democratic event has already passed, the constitutional safeguard may no longer be capable of correction in time. This is what I mean by constitutional time. Political systems often move quickly. See, it's like the two train tracks, and this is why I'm talking about the relativity, the idea of relativity is the thing that came to mind here. The political system, fast, and the legal system moves slow. So you can see there's a problem between the movement, where political time outruns legal time, constitutional review may arrive too late to matter. This is not only a legal problem, it is a constitutional problem. Now, this is very high this is kind of very constitutionally, it's constitutional theory, so it is very, it is very difficult, I suppose, to follow perhaps. But I mean, I have to, this is part of my research, and I think it's a major insight. So I'm trying to share it, I'm trying to describe it in as simple language as I can. Because a constitutional safeguard that cannot be invoked in time may become a safeguard in name only. Now, one of the most important mechanisms in this problem is what I call procedural reframing. And this is what my most recent paper is about. Procedural reframing occurs when a serious constitutional question is not answered directly as a constitutional question. I mean, this is unbelievable, but is redescribed as something smaller, narrower, more technical, or less constitutionally significant. For example, a case about democratic structure may be reframed as a personal complaint or a personal grievance. A case about access to a constitutional nomination route may be reframed as disappointed by an unsuccessful applicant. A case about the functioning of constitutional safeguards may be reframed as a political issue or non-justicable. In other words, a case about urgent constitutional review may be reframed as a timing problem. A case about institutional malfunction may be reframed as an abuse of process. A case about democracy may be reframed as an inconvenience to ordinary administration. Once this reframing happens, the constitutional issue can disappear from view. So a constitutional case goes into the courts and it's allegedly reframed in this way, and the judgment then, there is no constitutional issue. It's shocking. It's absolutely shocking. The court may still hear the case. I actually didn't even know about this technique or this method that's sometimes used to shut down cases, but it is widely used, or won't say allegedly. There may still be a judgment. Procedure may still be followed, but the deeper constitutional question may never be answered. So because of the reframing, the constitutional question is hidden from view in terms of the judgment. It's shocking. Absolutely shocking. This is why procedural reframing is so important. I actually didn't realize before I did my research, this actually exists. I've heard all about manipulation. I mean, I read everything about narcissism and gaslighting and all the rest of it. I never heard about the procedural reframing technique that's used sometimes to shut down constitutional challenges. It can move a case out of the constitutional frame and into a procedural frame. It can change the question, is this constitutional safeguard functioning too? Is the applicant too late? Is this case premature? Is this purely political, a matter political or non-justicable? Would intervention be disruptive? Is this an abuse of process? Is this now moot? These questions may be legitimate in some circumstances, and indeed are, but if they prevent the constitutional issue from ever being reached in time, they become part of the constitutional blind spot. This is also where the global dimension comes in. This is what's really stunned me when I did the research. These techniques are not when I was doing the research, I was looking for patterns abroad that I found in Ireland, and in my case, or that I identified mine, and I was trying to see if there were these patterns that were elsewhere, visible elsewhere, are noticed. And yes, they were, but not in this particular. They were not named as a constitutional blind spot in this way. So across democracies, constitutional cases can be shut down, narrowed, delayed, or displaced by procedural doctrinal. That was known. They may include delay. That's a tactic or procedural doctrine. Delay, mootness, standing, rightness, non-justicability, judicial restraint, political questioning, reasoning, balance of convenience, cost risks, election finality, abuse of process, procedural technicality, separation of powers, objections, deference to political actors. We might call that undue deference to the political process or the political establishment, and institutional caution. Each of these doctrines may have a legitimate purpose. Standing asks whether the right person is bringing the case. Rightness asks whether the issue is ready to be decided. Mootness asks whether the issue is still live. Non-justicability asks whether the matter is suitable for a judicial decision. Judicial restraint reminds courts to be careful about interfering with other branches of government. The balance of convenience weighs practical Consequences. Election finality protects stability after people have voted generally. Cost rules may discourage frivolous litigation. None of these doctrines is automatically wrong. Well, they've been widely used for many, many years individually. The problem arises when they operate. This is where I found the issue here, where I found this insight. The problem arises when they operate together in sequence. This is what I call doctrinal layering. Doctrinal layering, I'm defining it as means that several legal doctrines of the type that I've mentioned here, or procedural barriers, are applied one after another in a sequence so that eventually the constitutional issue is never reached in time. One doctrine alone may not shut the case down, but several doctrines, time delay, non-justicability, procedural, reframing, all of these things, but several doctrines, abuse of process, may do so. The case may be said to be too early before the election, too disruptive during the election, too late after the election. It may be described as speculative at one stage, urgent and disruptive at another stage, moot once the event has passed. The result is this: too early, too risky, too late. And no effective constitutional review is available in time to prevent or correct the alleged constitutional violation. That's the main insight of my research. This is the time trap. It is one of the most serious features of the constitutional blind spot. It means that the citizen may never